Hi, I'm James.
And I'm Antony.
And this is Words and Numbers.
This week, Clark Neely joins us. Clark is Vice President of Criminal Justice at the Cato Institute. His areas of interest include constitutional law, overcriminalization, civil forfeiture, police accountability, and gun rights. Clark is author of Terms of Engagement, How Our Courts Should Enforce the Constitution's Promise of Limited Government. Clark, welcome back to Words and Numbers.
Always a pleasure.
I have to preface by saying you're, of course, always welcome, but this particular time you're back by popular demand. Our listeners have asked us, particularly since you did the episode a couple of months ago on the Chevron deference, when I guess at that point the Supreme Court had agreed to hear the case, and now they have heard the case and ruled, so we're asking you back to talk about that. And I understand you want to talk about the Judiciary case as well. The two go hand in hand. So I would just turn it over to you and tell us what's going on.
Don't forget to hit the immunity case while you're at it.
Wow, yeah, it's been a busy term. Of course, it's over now. And when I say term, I mean the Supreme Court term. Perhaps the highlight for libertarians was last week. On back-to-back days, the Supreme Court handed down two cases that really dealt a significant blow to the power and prerogatives of the administrative state. And of course, here I'm talking about all these federal agencies and the power and prerogatives that they've amassed over the past, let's say, century or so. And two of those are, in particular, first, the success that agencies had in arguing that when they interpret an ambiguous statute, in other words, Congress has enacted a law that gives to agencies some power to do something, whether it's, clean up the environment, make workplaces safer, whatever. If that law has some ambiguity, and frankly, which law doesn't at least have some ambiguity, agencies would then interpret the law and say, okay, well, we think this is what it means. And if somebody challenged that and went into court, a judge essentially has two choices at that point. The judge can either start fresh with the agency's empowering statute and decide what the judge thinks is the best understanding and meaning of that law, or, and this is what we came to call Chevron deference, the judge could defer to the agency's interpretation of that law as long as it was reasonable and say, hey, you know what? I might have come to a different conclusion about the scope of your power or whether this policy that you're enforcing is or is not the best interpretation of the statute, but I'm going to defer to you, agency, and so even if I might have come to a different conclusion, I'm going to let this stand. And for 40 years, between 1984 and 2024, the latter is how the courts went about it. They deferred to agency interpretations of arguably ambiguous statutes as long as they were reasonable. And that's a lot of power to hand off to the administrative state. And the administrative state made hay with that power. But that particular approach is done. The Supreme Court reversed the Chevron case, ended Chevron deference in a pair of cases that came down last week called Loper-Bright, and the second case was Relentless, but they put them together and now we just call them Loper-Bright. And from now on, the court is going to start fresh with the statute, the language of the statute. Whenever agency action is challenged, there will be no more deference to the agency's interpretation of the statute. The court will decide what is the best meaning, best understanding of that statute, and that's the one that will stand. So that's a really big deal. And then very quickly, the second case that we mentioned is called Judiciary versus SEC. And this involves whether the Securities and Exchange Commission can initiate a civil enforcement action against you where there may be millions or even tens of millions of dollars at stake because they've accused you of some wrongdoing, and then shunt you off into an agency adjudication where instead of a neutral jury of your peers, the case will be decided by an administrative law judge who is employed by the same agency, the SEC, who created the policy at issue and then initiated the enforcement action at issue. And then the judge who works for that same agency would then decide the case. And you can imagine where citizens wanted to be. They wanted to be outside of that system and get a jury trial. The SEC took the position, no, you don't get to do that. You have to stay here in our agency adjudication and play in our sandbox. And the Supreme Court struck that down as well. And so now if you're the target of an SEC enforcement action, you can not only insist upon, but actually obtain your right to a jury trial if that's your preferred forum. And I'll give you a little pro tip, it should be.
You know, Clark, here's the thing, and it's a very strange thing, because what you just said seems so eminently reasonable that it's hard to imagine anyone saying anything else. And yet we have an entire group of people who are absolutely apoplectic about these decisions. Can you give us some hints as to why?
Nope, I really can't. I'll do my best, but James, as usual, you've understated the case.
I am prone to subtlety. That is correct.
So it's actually even more glaring, I think, than you suggested, because I left a couple of things out. In the Loper-Bright case, where the Supreme Court overturned the Chevron doctrine, the Chief Justice who wrote the opinion emphasized the fact that the Administrative Procedures Act, which controls here, and this is, I think it's a Truman-era congressional statute that sort of lays out the procedure by which administrative agencies do various things, specifically assigned to the judiciary the job of deciding, of interpreting the law. So in other words, the federal law that is at issue here specifically assigns to the judiciary the duty of interpreting statutes when they arise in this setting. And then the Chief Justice made a second point, which is, and if Congress doesn't agree with the result that we've reached today, on policy grounds, it can change the administrative procedures and require us to go back to deferring. He didn't exactly say it, but he inferred it. And so those who disagree with the result in Loper-Bright are really, I think, left to assert just a naked policy preference for a world in which administrative agencies have the prerogative to decide how much power they have and what they should do with it, or at least to have a much broader space in which to make those decisions and not have to go explain themselves to mere Article 3 judges and justify their interpretations of their, authorizing statutes. Look, I'll just be candid. I can't really get my head around why that would be so objectionable, other than to say, I think there's a class of people in this country who feel like we need a sort of proactive and vigorous federal government to go out and solve problems. And somehow they have a perception that either agencies have done a pretty good job of that in the past, or if they haven't, that somehow we're on the precipice of some magic era when they are about to do a really good job of it. And so the federal courts should stay out of the way. Of course, I can only step into the shoes of somebody who has that worldview, because it's certainly not mine.
Well, it's a difficult worldview to come to terms with, right? Because I think, the word that you just used, power, is really what this is about, right? This is really about the federal government having the power to dip into anybody's life, tell that person what he must do with absolute impunity, and leaving no recourse whatsoever for what I consider to be the aggrieved party. I mean, maybe I'm being too subtle yet again, but I think I'm not being too terribly subtle. This seems to be a complaint that a naked power grab has now ceased to work.
I'll add one thing. Maybe in fairness, we should also acknowledge this. I suspect that most people who object to the Loper-Bright decision and kind of mourn the passing of Chevron deference would also remind us just how dysfunctional Congress has become. And whereas we libertarians, sort of get a bit of a warm, fuzzy feeling about congressional gridlock, at least I suspect most of us do, there are certainly people who do not, and who feel like, look, Congress has become so dysfunctional that they just can't legislate anymore. And if agencies can't sort of take the football and run with it, then nothing's going to happen, and really serious problems are going to fail to be solved. And I get that. We're talking about an executive branch agency with a chief bureaucrat who does not have to stand for election, does not have to face the voters every 2 or 4 or 6 years, but can act pretty much unilaterally. And then, of course, there's also the problem of industries getting whipsawed every time you get a new administration that comes in and says, oh, okay, well, the outgoing administration got it all wrong, and we're just going to turn on a dime and change their interpretation of these statutes. So, hey, remember when we told you the whole electric generation industry had to change from fossil fuels to renewables? Haha, just kidding. You can switch back now. That's our perspective. That's what we see partly being at stake here. So, look, reasonable people can feel differently about this, but I still think there's a correct answer.
We're going to switch back, but we're only going to switch back for 4 years, and then we're going to go switch back again. And if anything in the American experience is a thoroughgoing violation of the separation of powers, clearly it's this.
James said that this is about power, and it seems to me there's something else at play that you were touching on, Clark. And that's the avoidance of responsibility. You get to a point that, look, the individual congressman, their goal is to get elected. To get elected, they need to say to their constituency, look, I voted for this law. And they always cite the title without any reference to what the law actually does. Well, the fact is, if we're in opposing parties and we both need each other to get this law passed so that we can go back to our respective constituents, and the law, if it's written in ambiguous enough language, we can both vote for it, understanding that the thing will get played out elsewhere. And if it turns out badly, that doesn't splash back on either one of us. It splashes back on the courts or the executive branch.
Or worse yet, no one at all.
Or no one at all. It seems that there's a built-in incentive to do exactly what has been happening, which is to slough off the Congress's responsibility onto the other branches.
That's exactly right. And there's a particularly vivid and poignant illustration of that was also a case that was handed down this term, the Cargill case, that involved these so-called bump stocks. These are little, devices that facilitate the near full automatic firing of a semi-automatic assault weapon by essentially enabling you to bounce your finger off the trigger so fast that you can generate a high rate of fire. And that appears to have been the system that was used by the shooter at the horrific mass shooting in Las Vegas several years ago. And the reason this is a perfect illustration is that in the wake of that tragedy, there appeared to be something close to a consensus that these so-called bump stocks should be illegal, and they weren't. There was no law making them illegal, notwithstanding the fact that you've got the National Firearms Act that criminalizes all kinds of different weapons, short-barreled shotguns, short-barrel rifles, suppressors, etc. So this should have been a light lift, but instead what happened? ATF under Trump decided they would reinterpret a law that they had consistently said does not cover bump stocks. And then lo and behold, we took a fresh look at it. Oh yeah, we missed it. It actually does cover bump stocks. And so those are now illegal. And so what this did was enabled members of Congress to share in the credit for eliminating this device that was part of such a horrific tragedy, but not have to expend the political capital, not have to stand up to some of their more ardent, let's say Second Amendment proponents in their district and say, yeah, I did vote for that, right? And then, of course, what happened? Well, the Supreme Court struck it down because why? Because it was not a plausible interpretation of the National Firearms Act and does not cover bump stocks, as the ATF had long concluded. And so now the issue is in front of Congress again. You might think it would be a no-brainer because this is a very marginal device. It's not good for anything really except recreational shooting and the occasional mass shooting, which is horrific. So why on earth would Congress not take the initiative here and ban these? And it's for exactly the reason I think, Ant, that you said, which is that they don't want to expend the political capital and accept the responsibility of stepping up, being counted, and saying, hey, you know what? I do support the elimination of bump stocks. And if you have a problem with that, come on by, the office and we'll talk it out. Well, guess what? That's the way Congress is supposed to work, and it doesn't anymore.
And before the hate mail comes flying in, I'm going to take issue with your use of the phrase assault weapon.
Modern sporting rifle, James. It's a modern sporting rifle.
I just remain unconvinced that there is such a thing, right? Because this is just a definition that Congress throws out there every few years. It gets redefined. It's largely on aesthetic grounds. And here we are. And I think when you think about firearms, you got the Second Amendment to deal with. Well, unless you're not honest about things. And Congress is traditionally very dishonest about this sort of thing, right? So it seems to me like the Supreme Court is doing a couple of things, and you could take umbrage all you want, right? But the Supreme Court is doing a couple of things to try to make American political life a little more rational, dare I say it, a little more constitutional. And if you have a problem with the Constitution, I think you should come right out and say it. And lo and behold, there's a process for you if you don't like something that's in or not in the Constitution. The amendment process is there. And honest politicians know that. It's just that there aren't any honest politicians.
I agree, and there's even more to love about Loper-Bright and the repeal of Chevron for those of us who favor constitutionally limited government. And it deals with this idea of what we call the non-delegation doctrine. And the idea here is that Congress is not supposed to delegate its lawmaking authority to anyone else, including an administrative agency, and yet it does. And how does it do that? Well, it often does that by writing extremely broad statutes where instead of describing some policy with reasonable detail so that everybody can understand, okay, this is the law and this is what the effect of the law will be, and then that goes through a democratic process, the Congress will instead say something like, hey, Environmental Protection Agency, make the environment cleaner. You figure out the details about how to go about that, That is a delegation of power that I think is clearly improper under the Constitution. It's been sort of the proverbial frog in boiling water where incrementally Congress has given away more and more of its policymaking authority illegally, I think, to administrative agencies. What's going to be beautiful about Chevron being off the books is that courts are going to have to confront more statutes, and they're going to have to do it sort of more forthrightly and try to figure out what the hell does this statute even mean? And when Congress is writing these incredibly broad, open-ended statutes, I think this is really going to drive home to judges just how gross the delegation problem is here, with Congress just writing these open-ended statutes that don't fill in really very many details. And I think a lot of judges are going to look at these and go, okay, so we're no longer deferring to an agency's interpretation. We have to figure out what this means. And you know what? I'm at sea here. I don't really know what this means because there's not a lot to go on. And hopefully this will drive home the underlying and arguably larger problem of Congress attempting to hand off its policymaking power to another branch, and specifically the agencies in another branch, as judges have to confront that dynamic from the front row now instead of from the last row. And hopefully that will focus their attention and cause them to maybe take a harder look at how much policy they allow, or how much of its policymaking power they allow Congress to delegate away to agencies.
Is this going to yield a situation in which judges hold Congress's feet to the fire? Or conversely, are we left with government by judiciary?
That second point is where I wanted to go. Do we end up here with essentially replacing these agencies with the judiciary? I mean, you can imagine in an extreme case, Congress authorizing or setting up some subdivision that answers to the judiciary that does functionally the same thing that the executive agencies do now.
Well, fair points. Let me start with perhaps a simplistic sounding illustration, but I think there's a real point to it. If you say to your kid, you don't get your dessert until you finish your homework, and your kid comes upstairs with, a math worksheet and all they've done is put their name on it, and their attitude is, well, that's, I've done the bare minimum. I think that's finishing my homework. I'm prepared to turn this in. If you're the judge in this situation, you say, no, you have to actually work through every problem. That's finishing your homework, and only then do you get your dessert. I think that's really what judges are now going to be saying to Congress. You have to dot the I's and cross the T's. You have to write something comprehensible, and it has to be a sufficiently specific articulation of the policy that you're not just handing off your policy-making power to agencies. I don't consider that to be government by judiciary. The default, by the way, let's make sure we're all clear on this. Let's level set. The default policy in this country when it comes to Congress is nothing. Inaction. It's Congress that has to surmount various hurdles in order to take action. So, for example, whatever it is that it wants to do has to be a constitutionally delegated power, in theory. Maybe we get back to that one day. But that's hurdle one. Second, it has to go through the presentment process, the voting and presentment process as described in Article 1. It has to present the bill to the president, et cetera, et cetera. So there's a procedure for getting this stuff done. And the idea of the judiciary simply saying to Congress, look, don't come upstairs with just your name written on a piece of paper, actually do the entire worksheet, and then you may have your dessert. I just think it's ridiculous to characterize that as government by judiciary. It's just the enforcement of rules.
But hang on, you're imagining a judiciary like we have now, at least at the Supreme Court level. What happens a couple of generations from now when we have activist judges all over the place and Congress passes a law saying, well, the environment needs to be cleaner, and you get an activist judge who says, okay, well, I'm going to interpret what that means.
Yeah, sure, but they were going to do that anyway, James, because think about it. So if you've got an administration whose agencies take a relatively narrow view of the power that statute confers, you just wait until a new administration gets elected, and then their agency heads will take a broader view. You don't really need the judiciary to facilitate this process. You wait long enough, you'll get the right bureaucrats in the right spots. And, as I think you guys know, like exercises of power tend to be sticky and sticky in one direction, right? So when an agency gloms onto a bunch of power, it's not as if you have to worry that it's all going to be clawed back the next time we get a president from the different party. Some of it might be clawed back, but not most of it.
I have to push back further.
Yeah, go push hard.
So there's a big difference between the agencies and the judiciary. And that is that with the agencies, if the voters finally say, look, we've had enough, we don't like this policy, we can vote in 4 to 8 years, another president who can at least put pressure one way or the other. I don't know about the federal judges, but of course, at the Supreme Court, they're appointed for life. You got to wait till one of them dies.
I guess where we're maybe missing each other here is that the judiciary doesn't have any power to order an agency to expand its power. At least give me a scenario, but that's not the usual.
No, that's not what I'm suggesting. What I'm saying is if we're in a space in which the agencies can no longer interpret the law as they like, have we now set the stage for activist judges to play with this new toy and say, well, we're going to interpret what this law means?
No, I don't think so, because think about it again. Even a creative judge doesn't sit here with a statute and say to an agency, hey, you've been underestimating the amount of power that you have. I'm an activist judge who thinks we should have a much cleaner environment, and I'm going to order you to force the electric power generation industry into solar or renewables of some kind. I suppose that's not inconceivable. I think that is a much less likely. First of all, somebody's going to be wielding power, and one question is, who do you want it to be? Right. And so what we've done essentially is move quite a bit of power, I think, over from administrative agencies that were clearly abusing it to a judiciary who, okay, granted, they might abuse it, but their ability to abuse it is much more constrained, I think, than the other two branches. And, judges, I'm not going to say that it never happens. There was the infamous prison litigation, like in the 1970s, where the judiciary was ordering prisons to adopt a bunch of policies that you could argue about. So there was some proactiveness there, but it is actually quite unusual. Usually what judges are saying to administrative agencies is, no, you're biting off too much, you're taking up too much power, you're pursuing a policy that wasn't clearly delegated to you by Congress. I am not going to lie awake at night worrying that one day an activist judiciary starts exercising more power and implementing more policies through, sort of injunctions and other forms of judicial policymaking than all of these administrative agencies. I just don't think public choice theory really works that way. And we're not talking about, what is the perfect approach here. We're talking about the lesser of two evils. And I absolutely think a judiciary that has clawed back more of the power that it always had away from administrative agencies that never should have been exercising that power is clearly the lesser of two evils in that scenario.
I think not only would I agree with that, I think almost any reasonable person would have to, right? Because you said it clearly enough that the judiciary can't enforce its own decision. It needs some complicit actor out there to help out. But I'll just point back to Brown versus Board of Education. Where on earth did the Supreme Court get that authority? It didn't exist, right? They claim it's coming from the 14th Amendment. That's a bunch of red hot nonsense. Of course, that wasn't the case. And the Supreme Court knew what it was up to, because having desegregated all of the schools in the entire country, it realized Washington, D.C. is not subject to the 14th Amendment. Oh, I know. It was this other amendment from 1791 that we just missed for 180 years. Go forth and desegregate D.C. That's the kind of activism. And you don't make any points, right, pointing to this, because we would all agree that desegregating schools is a laudable thing. You want to desegregate schools, right?
They might disagree with you, James. They might not do it on your podcast. They might put a pin in this. I'm not sure exactly what you meant when you said that you thought Brown v. Board of Education was steaming garbage or whatever you said it was.
Red hot nonsense, I said it was.
Yeah, okay, red hot nonsense. I would push back on that, but this podcast is not about that. Maybe I'll come back and fence with you.
Look, I would like to have a deep dive into Brown and bowling with you one day. I think that would be a valuable thing. Let's do put a pin in it. We'll get back to it on some week when there's not a bunch of Supreme Court decisions, a train wreck of a presidential debate, and all kinds of other red hot nonsense to get through in immediate term. So then back to Chevron. Where does it all lead? What's your best guess? And I agree with you. I think that this is clearly the lesser of two evils by a country mile. Everybody on the left is apoplectic the way they often get, failing to realize that they've had their way in an extra constitutional manner for 50 years at the level of the Supreme Court. And, well, guess what, Punkin? Now you lost. Go put on your big boy pants and deal with it. But that's not what we're getting. So what do you think we end up with here, say 5 years out? What does American political life look like? Do you have a guess?
I do. I don't want to stake out too much turf. I think we can safely predict that administrative agencies will, on balance, exercise somewhat less power and do so less ambitiously than they do now. I think it would be very difficult to try to quantify that. Are we talking about, a just discernible change, or are we talking about a real sea change? My guess would be somewhere in the middle. That's not a particularly bold prediction, I know. So I think two things are true. I mean, the Chevron doctrine was immensely agency empowering doctrine. So the elimination of that doctrine is a big move. On the other hand, we're talking about dozens and dozens of agencies with hundreds of thousands of bureaucrats who have become extraordinarily adept at, sort of exercising power myriad number of ways. And I think the idea that the judiciary can win this game of whack-a-mole, of power whack-a-mole, sort of hands down is a bit fanciful. Are they going to be able to whack more moles after Chevron being reversed? Yep, definitely. They're going to sort of run the table and create a situation in which administrative agencies only exercise that amount of power that has in fact been delegated to them by Congress and is also consistent with the Constitution? Absolutely not. If I got a chance to bet on the other side of that, I'd take that action all day long. But again, agencies are going to have to work harder. Congress is going to have to work harder. Judges are going to have to work harder to exercise power. And that, I think, should be music to anybody's ears who is in favor of constitutionally limited government, because those are, well, two groups at least that don't really like to work all that hard. I'm talking about Article 1 and Article 2 here. And so, given a choice between actually doing their homework or just foregoing their dessert, I think oftentimes they'll just say, well, it's not worth it.
And just to be really clear, I mean, I don't expect any of these agencies are going to just disappear. I'm assuming you don't either.
No, they're not going to disappear, but they're going to probably have to be more thoughtful about how they're going to prioritize, right? If basically, this is almost like reducing their power allowance, and they're going to have to now decide, what do you really want to spend this capital on? Because you're going to have less of it, and it's going to be more carefully sort of vetted and reviewed by the courts. And so you better choose carefully what you want to spend your political capital on, because you got less of it, and it doesn't go as far as it used to now that Chevron is dead.
I have to say, Clark, I've read some of the decision. I haven't worked my way through the whole thing yet. People don't realize how long and involved these things really are. When a decision is made, if you're a serious person, you're going to have to dedicate some real time to going through all of the decisions, right? Even getting through the facts of the case are sometimes very difficult.
Well, not if it was written by a justice whose ideology you don't agree with. Of course, then that completely exempts you from having to read the opinion, because you already know it doesn't make any sense. Otherwise, it wouldn't have been written by somebody you disagree with. Sorry, I'm being cynical.
I read the summary on Twitter. That's good enough.
That's good. I'm going to pretend like you never said that horrible thing, Clark, and say this, with the caveat that I haven't gone through the whole thing yet. It doesn't seem unreasonable. This decision, to me, to my eyes, from what I've seen so far, just does not seem like a bunch of crazy talk.
No, quite the opposite. I mean, if you look at it in the cold light of day, let's say that we could somehow turn back the clock 40 years to 1984, which is when Chevron came down. I wasn't there. I mean, I was in high school at the time, and I really wasn't probably paying attention to this stuff very much. And also, Supreme Court arguments were not broadcast then as they are now. But I just really wish I could hear somebody give an answer if asked point blank, why should judges be deferring to the legal interpretation of agency bureaucrats when the Administrative Procedures Act says that the courts will decide legal questions? Give me that again. right? And so not only is the Loper-Bright decision not unreasonable, it's hard to get your head around the idea that the opposite would be reasonable. Congress enacts the APA, says legal questions are for the courts, and then you've got a doctrine by which courts say, oh, well, only sometimes, but if an agency has interpreted the statute in a way that's reasonable, even if we disagree, let's just defer to them. And, we haven't really even discussed all of the public choice dynamics that come into play here when an agency interprets a statute. Hopefully, if anybody would understand that you don't want to have an image of a bunch of, pure as the driven snow bureaucrats, lying awake at night, thinking through a congressionally enacted statute and saying, like, what is the platonic ideal of how to most carefully and respectfully follow the literal language of this statute and enact the policy that Congress directed, but no more, right? That's not what happens. You've got agency bureaucrats who are subject to the very kinds of public choice dynamics that we know so well. Things like wanting to expand the parameters of their power, how to increase their budgets, how to go back to Congress and tell them you need more funding and more personnel, how to make sure, for example, that when you're done being the administrator of the EPA, that big spinning door on K Street churns out money and you get a big salary offer, right? Because you were so nice to your friends in the industry while you were in charge. I'm not saying that happens all the time, and I don't want to paint every agency bureaucrat, as fundamentally corrupt. But if you think none of this is on their mind ever, you're dreaming.
People who don't think about this every day, which I hope is almost everyone, right? This is not the kind of thing you want to think about every day, unless, that's your job, like you, Clark. When the question is reasonableness, well, who gets to decide what reasonable is? The answer to that question should point you directly to the problem.
I appreciate that, James. Just in case, I don't want you to feel too sorry for me. One of the reasons why I study the architecture of statism is so that I can understand where most effectively to place the charges and bring it down. So
Clark,
there is some hedonic payoff there.
Clark is speaking in metaphor right now. This is not Clark's plan.
Right. When I referred to the edifice of statism, I definitely wasn't referring to the Department of Education.
Stop it right now. You stop it right now. I think, look, that is the one cabinet post I think that we could all see disappearing. If any of them go, that one's going to be first.
Yeah, I hate to put you on the spot, James, but pop quiz, what do you think is the constitutional provision that the government would name as the delegated power that enables the Department of Education to exist?
Oh, that's a quiz I'm going to fail every time. I have literally not one clue. Not one clue.
It's a bit like the SAT.
I mean, look, it's interstate commerce, right?
Yeah, answer C.
You get this argument in Lopez. You might remember that if we have students who are frightened because of guns, then they won't learn. And if they don't learn, then they'll be stupid. And if they're stupid, interstate commerce, therefore. Right?
Yeah, did you remember there's actually, this is not a Supreme Court case, it's a case from the 11th Circuit Court of Appeals in which the question was whether the U.S. Department of Agriculture had the constitutional authority to dictate to the Hemingway Home and Museum in Key West, Florida, the conditions under which the museum's 3 or 4 dozen cats had to be allowed to sleep, because the cats were sleeping outside. And this apparently horrified one of the interns at the museum. And do you remember the hook? Because you're right. And it's going to be the Interstate Commerce Clause, but do you remember what the hook was?
No, the minute you said, do we have the authority? My answer was already no. Right? No, whatever the answer, no.
Yeah, so they sell cat-themed merchandise in the gift shop.
So if they just stopped selling cat-themed merchandise, we'd have to relitigate the whole case.
Well, no, they also have cats on their website.
Oh, there you go.
I'm not kidding. I'm not making it up, but yeah. Yeah. So anyway, I know we're going down not a rabbit trail. We're going down a
cat trail, cat hole.
Yeah, cat trail. Yeah. Yeah.
Can we say cat hole? The family podcast.
We probably can. So if we're making up stuff, is it time to talk about Trump immunity?
Yeah,
sure,
absolutely.
Sure. And you and I had a very brief exchange on this, which I think we're going to have a fight of some kind, although I don't know what kind of fight we're going to have. I was not terribly shocked by this, precisely because when you've got an arm of the federal government deciding if another arm of the federal government should be allowed to do what the hell ever, the answer is always going to be yes. I'm not surprised by this. I am a little shocked that the naked play at the end of a term to kick it so far down the road that it gets past the election, that was a little much for me.
I don't know that it was a naked play. All right, so let's set the table so everybody's on the same page. And now I'm going to have a doozy of a hypothetical for you. So the question in this case, this is the Trump immunity case arising out of the special prosecutor Jack Smith's prosecution of Donald Trump here in D.C. It's a 4-count federal indictment that is centered around Trump's efforts to resist, and some of us would say overturn, the results of the last election. And Trump asserted a new or a novel form of immunity from criminal prosecution on the premise that president simply cannot be, or a former president simply cannot be prosecuted for any acts that they took while in office. And that went all the way up to the U.S. Supreme Court, which handed down earlier this week what can only fairly be described as a rather abstruse decision that boiled down to its essence, essentially said this: there are 3 different kinds of acts that a president can take. One involves core constitutional responsibilities, things like granting pardons, appointing officers for the executive branch, things that are explicitly given to the president as his or her sole power by the Constitution. Then there's a second kind of activity involving acts that are official acts, but they are in a sort of a further out zone than these core constitutional acts. And then there's a third category, which is unofficial acts of a president, things that are not their official acts. So this would be things like playing golf at Bedminster. I suppose if Donald Trump chased a ball boy around Bedminster with a 9-iron, this would be not any kind of official act. So what this court held was that presidents are absolutely immune from criminal prosecution for anything they do when exercising core constitutional powers like the pardon power. They are presumptively immune for what they sometimes call these outer perimeter official acts, so acts that are official but are not core constitutional responsibilities. And that presumption of immunity can be overcome if the government can show that the prosecution of the president for a particular act within this intermediate zone would have no effect on the executive branch decision-making, on the president's ability to do their job. And then the third zone, the unofficial acts like trying to assault your caddy at Bedminster, no immunity whatsoever. So there's tremendous amount of disagreement and discussion about exactly what are the implications of the decision. How do you actually apply it? In this case, the Supreme Court held that one of the counts in the indictment that had to do with Donald Trump essentially threatening to fire a representative of the Department of Justice if they did not open investigations into supposed election irregularities, that is within the core presidential exercise of core presidential powers. That is, he is completely immune from that. So that one is done. The other 3 counts were returned down to the district court to apply this, I can only say, very convoluted test that the Supreme Court articulated, both to determine what zone the exercise of power falls within, and if it falls within this intermediate zone of sort of discretionary powers that are official but not core, is the presumption of non-prosecutability overcome or not overcome? So you are correct. There is no chance this case goes to trial, in my judgment, before Election Day or Inauguration Day in January. And I think probably, well, I don't want to predict. But of course, as Donald Trump, if he's elected and becomes our next president, he can just dismiss the case. And so I think the odds of this case resulting, coming to a final conclusion other than just sort of either dying with a bang or dying with a whimper, I think those are the 2 most likely outcomes, but I don't see it resulting in an actual judgment after a jury trial.
Right. Well, what's the hypothetical?
Okay, so here's my hypothetical.
I have one too.
So there's been much discussion and debate about whether, for example, there is any way to prosecute a president for granting a pardon, right? And I think the best reading of the decision is no. That's a core power. You're not even allowed to ask what the president's motivation was. Did he sleep with the guy's wife? Did he get a suitcase full of money? Whatever. Now, here's my hypothetical that I haven't heard anybody else ask. Imagine the president says, yes, I will grant you a pardon, provided that you come into the Oval Office and before your entire family commit ritual seppuku, cut out your guts and spill them onto the carpet of the Oval Office in front of your family, and I will then pardon you so that your family doesn't have the stain of your felony conviction on the record anymore. You're telling me that's not prosecutable? Well, that seems to be the implication of the Supreme Court decision, and I think that's one of the reasons why it kind of sticks in the craw of a lot of people who feel like this is a rule of law nation, and the possibility that that hypothetical, ridiculous and remote as it seems, and let's be clear, the bribery one is not so ridiculous and remote, but let's stick with the harder one, that a president could not be prosecuted for such an utterly perverse and malicious act is something that doesn't mean that it's wrong, but it's real hard to get your head around.
Yeah, no, I think you're ultimately right. That would just have to lay there. It's probably a sign of the times that your hypothetical doesn't seem all that far-fetched under the current circumstances.
It wouldn't just lay there.
It would have to.
No, it wouldn't, because we're looking to the judiciary to right that wrong, when in fact Congress is the one that would right the wrong through impeachment.
Only by impeaching him.
Right, exactly. So it's not that it would just lay there.
Impeachment is not a murder conviction. It's impeachment. You lose your job.
Right.
He'd get away with it.
Oh, I see what you're saying. You're implying that the impeachment and removal would necessarily take place after the pardon. Or excuse me, after the
death. The pardon precedes the death, There you go.
So James, I got another question. I got a question for you. I used to get this one a lot when I was litigating libertarian constitutional cases involving the assertion of certain rights that some judges considered rather fanciful, like the right to earn an honest living.
Yeah.
So my question for you is, if you believe that a former president enjoys at least some measure of immunity for acts that they undertook while in office, which provision of the Constitution do you think is most plausibly read to supply that immunity?
Well, let me say, I don't believe that. I'm not surprised that the court found it.
Right.
I think any rational person would have said walking in, well, of course, that's what's going to happen. But, when Joe Biden comes out and he starts slamming away at it the way he does, and he's had lots to say about the Supreme Court, which I think is in bad taste, significant bad taste. And other presidents have not done that, even when they disagreed wholesale with what the court was doing, because they knew that the legitimacy of the court mattered. And Joe Biden doesn't know that. But think about that fiasco of when we left Afghanistan. People died. Should Joe Biden be on the hook for a murder charge after he's done with office? When he retires, should we be able to go after him for that? I think he would say no.
I think that's right. And, there has been talk about whether he could be prosecuted for conspiracy to disrupt the enforcement or the application of law around the southern border, right? And you could imagine rolling into that conspiracy one or more of the horrific murders that have been perpetrated by illegal immigrants recently. Yeah, so
let's just call him an accessory, right?
Right.
Do we really want to live in that world? And look, I get immunity when you start talking about things like that. Is it a perfect tool? No. Is it going to be abused? Yes. Is it a necessary evil? Maybe.
Yeah, I think that's right. I think there have been a number of dynamics and shifts in culture that just somehow add up to a new kind of environment here. I mean, try to get your mind around the idea of somebody seriously threatening to prosecute Jack Kennedy for something. I'm sure he committed some crimes in office, right? And had he not been assassinated, I just can't conceive, not because it would have been implausible, but instead because it's just something that you didn't do. Now, if he had beaten somebody to death in the Oval Office, sure, I could imagine him being prosecuted for that, but not for, presidential actions, no matter how much you might have disagreed with them. Some of this falls under the heading of what's now come to be called lawfare, and this idea that the law is the weapon that is as available as any other weapon to employ against your political opponents. And, somewhat similar to the idea that, as a lawyer, your obligation is to zealously advocate for your client, even if that entails making arguments or taking positions that you find personally distasteful. That seems to have sort of seeped into the cultural consciousness now, where if prosecuting a former president who failed to secure the border seems to you the best way to ensure that the next Democrat is more careful about that, well, guess what? Let's push that through the system and just see if it works. And maybe it will and maybe it won't. And I think ultimately for me, a big takeaway here is that the criminal justice system, I think, has largely lost its ability to reliably distinguish between actual criminals who not only deserve punishment, but whose punishment is required for the safety and peaceful perpetuation of civil society on the one hand, and mere transgressors, just somebody who said, you know what, I disagree with you about what intoxicants I can put in my body, so I'm going to put in one that you said I shouldn't. I don't think there's any moral basis for prosecuting the second person, and our system has lost sight of the ability to make that distinction, and I think fundamentally that's what puts presidents at risk of criminal prosecution going forward. So maybe we never needed this doctrine before, because two reasons. First of all, it's relatively recent that our criminal justice system has lost its ability to reliably distinguish between genuinely criminal people versus transgressors. And second, because of what the cat dragged into the Oval Office in 2016.
Yeah. Yeah, no, it's gotten to be quite a mess. I don't know what else to say about it.
Well, let's hope that the Supreme Court does not have very many future opportunities to develop this new doctrine on presidential immunity for criminal prosecution.
That would be ideal, wouldn't it? On that happy note, I think that's probably the most optimistic thing that anybody has said in this conversation, so probably best to leave it right there. Clark, thanks for coming.
Thanks for your time, Clark.
Yeah, no, this was much appreciated. I think there's a lot of people who are asking us to get you back on, to get into this. So thanks for making that happen.
And let's remember the Brown Board of Education for a future episode.
Yeah, and I might even like to debate that with you.
I would totally do that. I think that'd be a lot of fun.
I think so too. And, you know, I always like running the risk of maybe learning something.
Well, you know, this is a really good topic because there's no, I think, ineluctably right answer here. There are probably just better and worse arguments, and I wouldn't predict who will end up, you know, feeling like they made the better or worse one. Hey, listen, guys, always a pleasure. I want to thank the listeners for being so hospitable, and both of you. It's always a treat to be on Words and Numbers and to have the opportunity to participate in a sincere conversation about civic life. I hope everybody gets that opportunity, and it's a pleasure to do it with you. They're few and far between.
And that's all the time we've got this week on Words and Numbers. Until next time,
Send us email, wordsandnumberspodcast@gmail.com.
try to be nice to one person who doesn't deserve it. Till next week, can't take it easy.
See you next week, James.